Hello everyone, Jai Hind and welcome to the platform of SRIRAM's IAS once again, and in today's session we'll be discussing about the rest of the fundamental rights. We have discussed about the right to equality as well as we have discussed about the right to freedom in our previous sessions. But in this session we'll be discussing the rest of the articles, rest of the fundamental rights that are given under part 3 of the Constitution. But before moving ahead, let me tell you that we are offering you with 1:1 free mentorship at SRIRAM's IAS. What you need to do is you need to go through the description box. There is a Google form. You have to fill it out, and whatever the doubts, what are the questions that you have in mind regarding the preparation for your UPSC Civil Services, that would be taken care of by the trusted mentors at SRIRAM's IAS. Alright, so that will be all, but we'll study about the rights or fundamental rights in today's session, the rest of the rights that we have spoken about. Now, we have already covered the right to equality. Alright, we have already covered right to equality in our previous session. Alright, that is from Article 12 to 18. The next we have covered already is the right to freedom, that is from Article 19 to 22. And today we'll be covering the rights, the right against exploitation, that is mentioned under Article 23 and 24. The freedom, right to freedom of religion, that is given under Article 25 to 28, as well as the cultural and educational rights under Article 29 and 30, and the constitutional remedies, that is given under Article 31A to Article 35. Alright, so when it comes to the individual liberty, so the part 3, it actually puts a balance between individual liberty with the social justice. Now, the first right of today is Article 23, that gives the prohibition of, or that provides for the prohibition of traffic in human beings. Alright, now there are 3 core protections that have been given by Article 23. It is that the traffic in human beings is prohibited. Along with this, begar. Please remember, it's not beggar. It's begar that have been prohibited. Begar means forced unpaid labor. Alright, that has been prohibited. And the similar exploitative practices which are equivalent to begar, they have been prohibited by Article 23. Now over here, the state have the power to enact the laws to punish offenders and also enforce dignity of such individual. Now there is a landmark case that happened, and it was PUDR versus the Union of India in 1982, where forced labor was, or it was pronounced that the forced labor also include the underpaid work. And in 1984 Bandhwa Mukti Morcha case, it was pronounced that the forced labor or the begar, that also extends to the bonded labor systems. So that is why I said that begar, forced unpaid labor and also similar exploitative practices have been banned, or they have been prohibited under Article 23. Now Article 24 is for the protection of the children. Now over here, when we talk about Article 24, it prohibits and says that no child who is below 14 years of age shall work in factories, mines or hazardous occupations. Alright, over here there is different laws which have been framed for the realization of this goal, that is that prohibition of the child labor in India and for the protection of the children, and that is Child Labor Act of 1986, which was later on amended in 2016, because this act actually was in contradiction with the right to education, where we have provided for the free and compulsory education for 6 to 14 years of age. So over here, this was amended, Child Labor Act of 1986 in 2016, for giving the comprehensive protection and for aligning this act along with the Right to Education Act. Alright, at the same time, when we are talking about MC Mehta versus Tamil Nadu case in 1996, there was rehabilitation directives that were issued in this particular case, and that was related to Article 24. Now next comes, the right to freedom of religion. Now we are moving from the social to the spiritual freedom, and over here Article 25 to 28 provides and they protect the freedom of religion. And basically when it comes to the Indian preamble, there is a word secularism or secular that is used in the when we are talking about used in the preamble. So it is a basic structure and it protects that basic structure, secularism in India. And over here, it provides for faith freedom, all right, along with public order, morality, and health, which have been used for the restrictions for this particular, rights which are there. Now, Article 25 gives for the freedom of conscience as well as religion, and everybody, every person in India have the right to profess, that is, hold or express his religious beliefs. He has the right to practice, that is, perform the rituals and observance related to any faith, and also he has right to propagate, that is, share faith with the others. That are the rights given under Article 25. Over here, the state can regulate the secular activities linked to the religion and also reform Hindu institutions for the social welfare. Over here, there are two prominent cases which have to be looked after. We have Stanislaus versus MP in 1977, where it was said that the right to propagate a religion, where you have the right to convert or share your faith with the others. So right of conversion, or where we have to, propagation, it is actually not equal to conversion by force. So that was laid down. That means that you cannot ask anybody by force to convert into your religion. And also in S.R. Bommai case in 1994, secularism was declared as the basic feature of the Constitution. The next article, Article 26, and right to freedom of religion, is for managing the religious affair, where every religious denominations, whatever the denomination is, they have the right to create and maintain institutions for the religious as well as for the charitable purpose, and they have full autonomy in the matters of religion, subject to public order and morality when it comes to administration of such institutions, and they have the right to acquire, hold and administer property according to law that has been given under Article 26. So I'll come to that later on, but let me tell you that the right to property that was given to the individual was taken away by 44th Amendment Act. But over here you can see that the right to property is actually given in the name of the religious denomination. And over here again we have a prominent judgment, Ratilal Panachand Gandhi versus Bombay in 1954, where it was affirmed that the religious management autonomy is the integral of, or it is integral to the freedom of religion. Alright, so this is again a very prominent case. The next article is Article 27, that gives for the financial secularism, and over here it has been said that no person shall be compelled to pay taxes for the promotion or maintenance of any religion. Alright, so over here the state maintains financial neutrality towards all the religion. All the religions are equal in the eyes of the state. And also when we talk about the judicial interpretation, so in Commissioner HRE versus Lakshmirandra Swamy in 1954, there was a distinction that was made between secular as well as religious fund usage as well. Article 28 provides for the prohibition of, or it says, or it lays down that no religious instruction will be provided in the educational institutes. Alright, it says that no religious instruction will be given where we have the educational institution that has been wholly funded by the state. Over here, the state maybe, it can be center for, or it can be the state as well. Alright, but it is permitted in the endowment institutions. Alright, permitted where endowment requires it, even if it is state administered, and also it is neutral yet accommodative secularism that is there. And that is why you will see that there are certain educational institutions which are endowment based, and it is required over there to impart the religious teachings, and that is why there are religious instruction that are imparted in those educational institutions. Alright, so that was the right to freedom of religion. Now comes the cultural and educational rights. And in this we have the first right, that is Article 29, that gives for the protection of minority interest. And it says over here, although it says protection of minority interest, but this is for whole of nation. Alright, it states that there is, or it protects cultural and educational rights of minorities and all citizen sections. Alright, it says that anyone who have distinct culture, alright, they have distinct culture, script, or any kind of distinctive, cultural heritage, they have the complete right to protect the same. So it goes for everyone. But over here, who has the more of, you can say they have more of endangering their loss of cultural heritage. So it is the minorities, all right. So therefore, it says protection of minority interest, and it says that there will be conservation of distinctive language, script of culture. Anyone who have a distinctive language, script or culture, they have the authority, or they have complete freedom to preserve the same. And as well as there would be no discrimination in admission to state or aided institutions. Over here, when we talk about the historic case, so there was Champakam Dorai Rajan versus Madras State, where it was the first Supreme Court case where it struck down the state law for violating the fundamental right. And again, it is very important case, Champakam Dorai Rajan versus Madras State. The next article is Article 30. When we are talking about Article 30, so it is over here for the educational institutions which have been established by the minorities. So it states that the religious and linguistic minorities, please remember over here, there are only two ways how the minorities are basically, you can say, they are, acknowledged by the Constitution, and there are only two ways, that is, either there are religious minorities or there are linguistic minorities. And also, please remember over here that there is no definition for the minorities that have been provided. There is no definition that have been given for the minorities. Alright, so the religious or linguistic minorities can create educational institution, and also they have full autonomy in institutional management as well as for the policies, and the state shall not discriminate in the grant of aid when it comes to the religious or the linguistic educational institutions. Alright. There was an important case in 2002, TMA Pai Foundation, where it was defined the scope of minority rights comprehensively, and also St. Stephen's College in 1992, where it protected the admission rights of the minority institutions. The next article is Article 31. That was the right to property. However, it has been now, it has been taken away or repealed by the 44th Amendment Act in 1978. It was a fundamental right. The right to property was a fundamental right under Article 31 and Article 19(1)(f). I told you there were earlier 7 rights in Article 19. Alright, but it was taken away by, or it was repealed by 44th Amendment Act in 1978, and right now it is a legal right under Article 300A under Part 12 of the Constitution. Alright, now this was taken away so that the land reforms can be done in our country. And for that, Article 31A is there that protects the agrarian reforms, as well as there are scope of protection that relates to the agrarian reforms and land distribution, acquisition of estates and feudal holdings, and restructuring property relations to equity. That is, when we are talking about this, it is all about the land reforms that had to be there or were conducted in India. And also it cannot be challenged under Article 14, that is right to equality, and Article 15, that is right to freedom. And there was I.R. Kaulo versus Tamil Nadu case in 2007, where Supreme Court has pronounced that even protected laws are subject to the basic structure doctrine, and they could be judicially reviewed. Article 31B is all about the 9th schedule. Again, when we are talking about Article 31B, it was added or introduced, or it introduced the 9th schedule in our constitution that relates to the land reforms. Or we can say that there are certain laws which are included over here which are immune to the judicial review. Alright, the original intent was to shield the land reform acts further from the judicial review, but over here in I.R. Kaulo case in 2007, the Supreme Court said that if those laws, they violate the basic structure, then they are reviewable and they could be reviewed easily. There are total 284 laws in the 9th schedule right now. Primarily, they concern about the land reforms, agrarian reforms, but its absolute immunity was curtailed to preserve the constitutional sovereignty. Alright, there is Article 31C as well. Article 31C was added for the distributive justice, and over here two directive principles of state policy, that is under Article 39B and 39C, they were given precedence over the fundamental rights. All right, they were given the precedence over the right to equality as well as right to freedom, or Article 14 and Article 19. So they were given precedence over Article 14 and 19, and in Keshwanand Bharti case, it was upheld that there is a limited scope of the Article 31C. But in Minerva Mills case in 1980, there were more of the directive principles that were added later on to the Article 31C, but it struck down the expansion and said that the expansion could not go beyond Article 39B and Article 39C. Now, the most important article of our constitution is Article 32, which had been said to be the heart and soul of our constitution by Dr. B.R. Ambedkar. It provides for the right to constitutional remedies, and also there are 5 writs which have been provided over here: habeas corpus, mandamus, prohibition, quo warranto, as well as certiorari. And over here, if any fundamental right have been violated, you can move directly to the Supreme Court and you can invoke the writ jurisdiction of the Supreme Court under Article 32, and that is why the Supreme Court acts as the guardian of the fundamental rights. That was it was proclaimed in Ramesh Thapar versus Madras case in 1950. That was the first case that was under Article 32. Over here we have 5 different rights, and they are, we have habeas corpus. Along with habeas corpus, we have mandamus. Then we have, along with this, we have quo warranto, even prohibition, and we have certiorari. Now, what is the difference, or what all these writs mean? They are the pronouncement of the Supreme Court under special conditions. Mandamus, when we are talking about habeas corpus, it means to have a body. So it is pronounced whenever a person is wrongfully detained. So in that case, a person can move to the Supreme Court and file for the habeas corpus writ. Then we have mandamus, that means we command. We command means that the Supreme Court or the High Court has the writ jurisdiction under Article 226. So there are Article 32 under which Supreme Court can pronounce these writs, and we have Article 226 under which the High Court can pronounce these writs. Mandamus is we command, where if a public official has not done his duty properly, or he has denied and said that he is not doing his duty, so there the High Court or the Supreme Court can ask them or command the public official to conduct his duty dutifully. Alright, then we have quo warranto, that means by what authority? By what authority? And this is also against a public official. Alright, if he has or she does not have the qualification to hold that post, so the Supreme Court or High Court can ask that by what authority you are on this post, and then he or she will have to justify the qualification, and then only he or she will be able to hold that post. The next is prohibition and certiorari. Alright, prohibition and certiorari, they have a very quite a similarity that is there when it comes to the the jurisdiction that we have. So we have jurisdiction of the courts, we have lower courts. Alright, above lower court we have High Court, then we have Supreme Court. All the courts have their own particular jurisdiction that is there. Alright, now if a lower court, it exceeds its jurisdiction, so the upper court can ask the lower court not to proceed with the case. Now there can be 2 cases. If the case is still ongoing or the judgment has been pronounced. Now if the judgment is pronounced, now what will happen? The judgment will be quashed because it exceeds the jurisdiction of the lower court. So if when we are talking about prohibition, it is to prohibit or to stop. Alright, to prohibit or to stop. So it is when the case is still ongoing. Alright, and in that condition, what will happen? The higher court will say, or it will tell the lower court not to proceed with the proceedings in the case. And when it comes to certiorari, it means to be certified. And this is where when we talk about what? When we talk about the certiorari, it is basically I'll say that when the judgment has been or the order has been pronounced. So where there is pronounced order, so that order will be quashed and then the case will be transferred to the higher court. So that is certiorari. Now there is also one more difference when it comes to prohibition and certiorari. Prohibition can be, it is issued against judicial as well as quasi-judicial authorities. Alright. But when it comes to certiorari, the certiorari can be issued to judicial authorities, it can be issued to quasi-judicial authorities, and also it can be issued to executives as well, whether permanent or the we have the permanent as well as temporary executives. Permanent are what you will be. Alright, the administrators which are there, and we have the temporary executives which are the ministers. So the certiorari can be issued against executive actions as well. Now when it comes to Article 33 to 35, they are structural safeguards, where Article 33 lays down that the Parliament may modify rights for the armed forces, the police as well as intelligence agencies. Article 34 gives or provides restriction or rights while martial law is in place or in force in any area, and Article 35 provides that the Parliament have the power to legislate for implementation of the rights which are given under Part 3 of the Constitution. In this way, we have the complete interconnection that you will see when it comes to the fundamental rights. They are basically, they protect the basic structure, they are safeguarded by the judicial review, as well as there is a harmony and not hierarchy between directive principles and fundamental rights as had been laid down in Minerva Mill's doctrine as well. Now there are certain challenges and the contemporary relevance when it comes to the human trafficking and bonded labor. So despite Article 23 that we have seen that there is exploitation that persists in informal sectors and the supply chain, which is again a contemporary challenge that we have right now. When it comes to the testing limit of secularism amidst the communal tension and the identifying politics, identity politics. So there is a religious polarization that you will see that the current India is ongoing. All right. And as well as there is National Education Policy of 2020 and educational autonomy concerns for the minority rights institutions, and therefore the minority rights are under pressure. And there is need for Article 23 type of protection in the data privacy as well as digital labor rights, and that is again one of the major relevance and challenge that we have today. So that is all in today's session, but at the same time I will say that we have, when it comes to the constitutional morality that is in action, we have equality with social justice that have been laid down by the fundamental rights along with the directive principles. We have secularism, where we have plural religions which coexist together in India as well. And we also have freedom with the responsibility. So the Constitution is not a document for the lawyers. It is basically a complete it is a complete vehicle for the life or of a life that had been said by the Dr. B.R. Ambedkar in his constitutional debate. So with this note, I will end this, and we have we have covered the complete fundamental rights right from Article 12 to Article 35. I'll see you in my next, where we will be discussing about the directive principles of state policy. Thank you. Bye-bye. Take care. Jai Hind. And do not forget to like, share and subscribe to our channel. Thank you. Bye-bye.